Hello, everyone, and welcome to the third webinar in our disaster webinar series. Today, we're going to hear about representing homeowners after a natural disaster with Lynn Drysdale and Alys Cohen. Lynn is a consumer protection attorney with Jacksonville Area Legal Aid, where she is the division chief for the Consumer Advocacy and Litigation Unit. Alys is a staff attorney with National Consumer Law Center, where, among other things, she directs their disaster response work. I'm Kathy Grunwald, the Disaster Coordinator Attorney at Legal Services of North Florida, and I'm here today with Carlin Selders, our Disaster Program Assistant. Today, if you have any questions, type them in the Q&A box. We'll try to answer them along the way and at the end of the webinar, time permitting. The webinar is being recorded, and I'll email you the link to the recording, send all the material and the CLE material as well to you next week. And if you look on the screen right now, you can see the Florida CLE number. After the webinar, you're also going to be asked to complete a short survey of the program today, and I hope you'll take the time to do that. Finally, I want to thank you for joining today and encourage you to come back each Thursday at noon Eastern Time for the remaining webinars over the next 5 weeks. And with that, I'm going to pivot to our presentation with our presenters.
Good afternoon, everyone. We really appreciate your participating today. And I am honored to be doing this with Alys Cohen, who is the consumer law guru from the National Consumer Law Center. It's been a real honor for me to work with her. And I know you're going to really enjoy the information that she has to offer, as well as the other information. So this presentation was supposed to have been done in March, live in March. And as we all know, March turned out a lot different than we all anticipated. And so our PowerPoint presentation and our presentation in general was very different in February and January, when we were putting it together for a 90-minute program to take place live in March. So we have pivoted and redrafted the PowerPoint so that we also include one of the biggest, I guess I can say, natural disasters that we have had, meaning the spread of the COVID virus. So we have a lot of slides. We're going to go through them very quickly. We have included slides that we are not going to have an opportunity to get to today, we're sure, but we wanted you to have the information. If you get, and we're going to try to take questions as well and answer them. But if there's something that you miss from today, or if you need to follow up or you were unable to ask today, please feel free to contact either one of us after the webinar, and we're happy to tell you more or answer your questions. And keeping in mind that, particularly with the COVID relief, this is an ever-evolving thing, so things that we tell you today may not be true tomorrow or the next day. So we're all just trying to adapt and tell you what we know as of today. So, and I believe we're going to start out with a poll question. And so we're just trying to see gauge the audience to see how many people have tried to take advantage of the forbearance programs, the different forbearance programs that have been offered through the CARES Act. So if you could please provide your answer, I'll pause a moment and Carlin will take over from here. Okay, I think everybody's seeing the results. Glad to see that double the amount of people that have tried to get a forbearance were successful in doing so. I see that very few on the call have tried, and that may be because you don't have eligible borrowers or for other reasons, but hopefully you'll have a lot more information after today that will help you as you move along and trying to take advantage and get the most and best use out of the different programs that are available. Okay, so first we'll talk about what we had intended to talk about initially, which was primarily what we thought would be important for natural disasters such as hurricanes, which we're pretty accustomed to here in Florida. So obviously, when thinking of a hurricane, which has a beginning and an end, which is perhaps not the same with the present other natural disaster, you know when the hurricane is past, so at that point you can take action. And so first of all, obviously you have to make sure everybody's safe, everybody's accounted for, and everybody's healthy. And then you need to look out for, is FEMA coming to town? Are there some sort of state options available for relief of all sorts? You need to also contact your insurance company, which is a good sign today to remember to keep your policies and perhaps all photos of everything that you have taken of value in your home. You'll have all of that information together. And then next, once everybody is healthy and in a place where they can stay momentarily, at least, a person needs to think about their mortgage and the things that you do to prepare, I guess, post-disaster with respect to your mortgage are going to be very similar to what you should think about in the CARES Act. So we'll be going over that in more detail. So the different options that are available, FEMA, which I mentioned, which we're all familiar with, the Small Business Administration sometimes has opportunities for people. The CARES Act, which wasn't even a thing in March, but we will talk in great detail about that today. The CDC, who knew that they were going to be weighing into the COVID relief effort. So we won't be talking as much about that today, but it is extremely important for particularly evictions. And so we're going to be providing more information about how to access assistance post-hurricane, but also now. So the first thing you need to figure out is whether or not you have your own insurance, assuming that you have a mortgage, or whether or not the mortgage company is force-placed insurance because you didn't keep the insurance for any number of reasons. You need to find the policy, as I mentioned, and figure out just exactly what is covered and what is not. In Florida, there's just sort of this weird thing where you have maybe 3 different types of insurance coverages: flood, wind, your regular insurance, and maybe even sinkhole insurance. So you have to figure out if it was a wind event or a flood event, the hurricane, because they can be both, and then figure out what type of coverage you have. And of course, have your home inventory handy along with photographs. I say these things like I have taken pictures of everything in my house and know exactly where everything is, but maybe I will after the webinar. So if you need to file a claim, you should. There are one of the things that can either be helpful or can be a scam is this concept of a claims adjuster to help you process your claims through with the insurance company. A lot of boutique industries arise after hurricanes, which we're all very familiar with, and included in those are claims adjusters, which sometimes take a little bit too much money from you to do what can or cannot be considered a service. And then you have to look at potentials for indemnification and responsibilities, or the insurance company's responsibilities with respect to that. So and then relating to indemnification, how much, who's getting paid, where's the first money coming to, will the insurance coverage cover all the damage, is there a gap? And what I'm talking about here is the concept of usually, well, always, if you have a mortgage, you have to list the mortgage company on your insurance policy as an also insured or loss payee. So it can get complicated as to who gets the check, to whom it's written, and then what happens after that with respect to between the borrower and the insurance company, which we'll talk about in the next few slides. So a lot of times the check will come to the borrower, but it will have the mortgagee or the mortgage company or the servicer's name listed as lost payee. So the borrower can cash the check, but they can't do that until after the servicer gets involved. But the problem is, so frequently borrower signs check, sends to the servicer explaining why, and then learns that the servicer has deposited the check and is applying it toward the principal as opposed to repairs. So that creates problems that we won't be able to get into fully today, but I just wanted to point that out. Also, trying to see if there's coverage for personal property, are repairs feasible? And let's go to the next slide to talk about that just a little bit more. So you first have to notify the servicer of the hardship and provide them good contact information. Generally, that's going to be a cell phone, so that's going to be the same after the disaster passes. You have to figure out who the owner of the loan is. Is it a Fannie Mae loan, Freddie Mac, FHA, VA, USDA? And we'll talk about that more in the context of the CARES Act. Is there equity, and can the homeowner keep making payments? Some of that may be a function of whether or not the homeowner has to find other arrangements and whether insurance covers those additional arrangements. So in a Fannie Mae standard mortgage loan document, meaning it's not necessarily a Fannie Mae loan, but it's that form is utilized, you can see that the insurance proceeds are supposed to be applied to fixing the property up as long as the repairs are economically feasible and the lender's security is not lessened. So that's going to be usually from the mortgage contract. What those two terms mean is not going to be in the mortgage contract, and so is going to be left somewhat ambiguous. But the courts usually look to see if the cost of repairs will exceed, and I'm assuming by a pretty good margin, the actual cost of the repairs, and if the value of the home when it's repaired is going to be roughly equivalent to the value of the home prior to the event occurring. And so lastly, with respect to insurance, this slide basically alerts you to all the potential problems that may be caused if the check is sort of floating around U.S. mail or is sitting in the bank account of the servicer. But I did want to mention that a lot of what the borrower's options are depend on if the borrower is current at the time of the disaster, and is the borrower able to get a contractor involved pretty quickly, and just making the determinations that the house can be saved, if I can just put it that simply. A lot of that will have a bearing on what happens next. And any problems with the insurance and that involve the servicer may be a good time for a notice of error or request for information, and we're going to talk about that in great detail later in the presentation.
Great, thank you, Lynn. Can everybody hear me? Great. So we're going to pivot now. We were just talking about insurance on the home, and the rest of the discussion is really going to be about the person who's paying their mortgage loan and what issues arise. And really, we're going to talk about it from three perspectives. Generally, when someone's facing a hardship, how does it work? How does it work in the age of COVID? And what are the specific disaster rules? And, you know, there are similarities and differences. But first, there's this other question. Can you go back one slide, please? Oh, sorry. You're right. It's the next slide. So first, the question really is, now we can do the next slide. I apologize. First, the question is really, who are you dealing with and what can they do for you? And so that is really affected by the fact that most loans are not held by the same company that originally made the loan. We have securitization on Wall Street, where they take loans in groups and they chop them up into little pieces and they sell off different streams of income to different groups of people and, trusts with investors. And so what that means is when the homeowner is having a hard time and they're having to figure out what to do, their home was destroyed, they lost their income, etc., they may want new loan terms. They may want to modify the loan and they have to figure out who to talk to about that. Or there may be a foreclosure or another type of lawsuit. They have to figure out who to talk to and then who gets to decide if it's over. They may want to get information about the loan from the company or demonstrate that the company does or does not have authority to deal with them, and they want to find out who has the original loan papers or who currently has the note that is essentially the lien on the house with the information about it. And so we're going to talk just a couple of slides about that, and then we'll go on and talk about hardship solutions. So the servicer is the mortgage company. And let me just also flag, there's a huge range of who is on the webinar today. There are people for whom this is your bread and butter, and there are people who don't regularly work on foreclosures. So we're going to just try to meet everybody's needs at the same time, and we appreciate your understanding about that. So a mortgage servicer is the company that takes the mortgage payments from the homeowner, but they're not the same as the investor or the holder, the party that actually owns the loan and is receiving those payments. The servicer is essentially the contractor for them. And so the problem with that is the servicer may accept the payments and pass them on to the trust, but the servicer also has their own incentives, and they don't always profit the same way that the investor does in terms of how the payments work and how they make money. We could do a whole webinar just on that. So what you're really going to need to know in order to help a homeowner is what kind of loan they have, which is the same question as who is the investor. And so we've been talking about the CARES Act. The CARES Act was passed in March. It was passed in response to COVID. It was the big relief package. There has not been another package after that. There was an act passed twice actually in the House called HEROES, and maybe we'll see it again in the future, but that didn't pass out of the Senate. And so we've got the CARES Act, and what it says is if you have a mortgage that's federally backed by, for example, a GSE, a government-sponsored enterprise like Fannie Mae or Freddie Mac, or you have a loan that's insured by a federal agency, like it's an FHA loan or a Veterans Administration loan or a rural loan through the U.S. Department of Agriculture, you have special rights. If you have a loan that isn't any of those things, and it's typically controlled by a mortgage pool, then it's generally controlled by what's called a PSA at the bottom, which is a pooling and servicing agreement. It's the contract between the servicer and the owner of the loan. And interestingly, a lot of those loans are getting access to things that are like what's in the CARES Act, but they're not required to do so. So now we're going to go on. Oh, I'm sorry, it said that PSA was cut out. That's a pooling and servicing agreement. Can people generally hear me? Okay. So now we're going to go on and we're going to talk briefly about the regular loss mitigation landscape. Loss mitigation is essentially assistance available to homeowners to mitigate their loss, the investor's loss, when there's a hardship. So first we're going to give you sort of the vanilla brand, and then we'll go on to COVID and disaster. So a decade ago, when we had the financial crisis, there was some reorganizing of how we think about how to help people who can't pay their mortgage. And there was a program called HAMP, that's at the top. And this was sort of the general template, just to give you a sense of what it has been like and what kind of the usual approach has been. First, you take the amount that people owe, their arrearage, and you roll it into the loan. You lower their interest rate. You make their term longer. Like maybe they only have 10 years left on their loan, you could extend it out to 30 years, sometimes 40 years. And then if their loan's still not affordable, you could even take some of what they owe and just sort of put it on the end for later. And the goal here was to get to a debt to income ratio of 31%, meaning let's find a threshold of affordability. The rules have changed since then, and there are a couple of new models now that we're going to talk about. So this is before the CARES Act, but it'll look reasonably similar with some differences once we get to the CARES Act and to disasters. So here in the first bullet, you can see there are 4 little boxes. First, if someone can just pay back the money they owe because their hardship wasn't very long or they have a ton of money, great, they can do that. If they are not in that situation, but they can return to their regular mortgage payment, which especially in COVID, some people are kind of going in and out of that, you can get this thing called a payment deferral, which we'll talk more about. And these are the rules for Fannie Mae and Freddie Mac on this page, but they also apply in some other contexts as well. So if someone can make their payment, they'll get a deferral. If they can't resume their regular payment, then they need a modification. They need to change their monthly payment. And if they can't even manage to afford that, then they're going to end up having to leave their house. And there are a variety of ways to do that through a short sale or a deed in lieu, for example. I think we should go on to the next slide. I have my hard copy here that I'm just looking at to make sure I remember all the points I want to make. So the big thing about a modification is it's supposed to lower your payment and make it affordable. And the main thing you want to know if someone has a regular loan, and most people who don't know what kind of loan they have, they often have a GSE loan. It's a Fannie Mae or a Freddie Mac loan. I just refinanced my mortgage yesterday, and it said, you know, Fannie Mae, you know, uniform, blah, 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 at the bottom of a lot of the pages that I signed. So what Fannie Mae and Freddie Mac have done is, instead of saying we're going to get a lot of information from you and figure out what you can afford, they've set up a system where there's a uniform way to lower someone's payment based on the percentage of your payment being lowered. That may or may not be affordable for the clients you're looking at, but that is the system that they have right now. And we're going to go into not very much detail, but it's in the slides. So there are 2 ways to get this kind of modification called the flex mod. The borrower can ask for it, or the mortgage company, the servicer, can figure out that the person's not making their payments and they can just offer it to the person and then wait for them to respond. So this is what a flex mod looks like. We're not going to go into all of the details, but the key thing to know here is that you're trying to lower the payment so the person doesn't owe more than the value of their home. You want the principal to not be more than 100% of the property's value, or you want to lower their balance by up to 30% of what they owe. So it's sort of the lesser of those 2. But the point is, you're trying to decrease the amount that they owe without trying to figure out what their income is. And sort of you go through these steps. So they're similar to that other waterfall, except it's not about the individual. And you can see here, this is step 5. If someone asks for help early on, they can even push it down to decrease their payment by 20% and to try to get their loan to value ratio to 80%, which is much better. So the early bird gets the worm, I guess, is what I'd want to say there. But maybe somebody doesn't have a Fannie Mae or a Freddie Mac loan. A lot of people have FHA loans, which are federally insured, and they have their own set of rules, and they kept their version of the old HAMP. They call it FHA HAMP. And the key thing to know here is it's different from the flex mod because it's based on the borrower's income. So there's a lot more back and forth, but in that back and forth, the goal is to actually make sure that someone can afford it. And a lot of these borrowers tend to be lower income, and so that's potentially helpful to them. There's also something called a partial claim. And of course, in all of these, if the person can't afford it, you end up with a pre-foreclosure sale or a deed in lieu. So on the next slide later on, when we talk about COVID, we'll talk a little bit more about partial claims and how those work. I really want to emphasize the importance of the servicing center for FHA loans. There's an email address in the middle here. It's different from other kinds of complaints. They will really try to clarify what the rules are and get the servicer to do the right thing, which in most other places, that's not true. And if you seek help from this particular servicing center and they're not giving you what you need, Lynn can help you get in touch with me and we'll help you get what you need. We're a regular thorn in their side, which we enjoy very much. And they're very, very good partners. So briefly, VA has a lot of options. We're not going to go through them all, but just remember that. And remember that there is this case at the bottom. I don't know, Lynn, if you want to say something about it. But every kind of loan has its own system, and so you want to make sure you know what you're getting.
Yeah, just briefly, that was a case that was handled by Donato Rinaldi, that pro bono, one of our star pro bono attorneys, and he was able to get a defendant verdict or judgment based upon the fact that the borrower was a veteran, and he was able to prove that the lender did not go through the options provided by the secretary and allowing the veteran to try to catch up his loans before filing the foreclosure. So the foreclosure was denied because they didn't follow the servicing regulations. And I think that that is the only case in Florida that I'm aware that's reported where that has been done for VA loans. There's several where if they don't follow the FHA guidelines pre-foreclosure, that can be the basis for a defense verdict. Thank you, Alys.
Okay, Lynn, you can take it away.
Okay, so we're getting ready to talk about the CARES Act. And before we do that, we're going to launch another poll question. And so this relates to I think 4% of you who were who tried to get a CARES Act forbearance and were unable to do so. So I will pause, check for questions or comments, and ask Harlan to launch the second poll question. I will mention, I know most of you have not attempted to get a forbearance, so I'm not quite sure about the other parts of the CARES Act and other types of borrower relief. But if you want to contact me after the webinar, then I can certainly walk you through the process that might be appropriate for your client.
The other thing I would say about this process is it may be for a lot of you who work with clients that people are getting forbearances without you, but they're going to come to you when their forbearance is ending because they can't manage to get into something affordable afterwards. And so that may be another pain point in which people show up in your office.
Right. Thank you.
It's interesting that the most common answer is it required too much documentation because the federal law says there is no documentation requirement, which we will discuss.
Yes. So if you responded that the servicer required too much documentation, contact me after this, and I'll walk you through putting together a notice of error. How's that? Okay, Carlin, I think we're ready to move on. Okay, so here's your statutory reference to the CARES Act. We'll pass through that pretty quickly. And the Florida moratorium, I know this is very helpful for people, hopefully for people who are representing defendants in evictions. I understand there's been quite a bit of drama relating to the CDC order because, one, I've heard it didn't have the authority, two, it's, various reasons why it's being challenged. But for right now, the CDC order is in place for evictions, and we will talk about foreclosure, moratoria, or forbearances continuing as we go along. So here are some resources. National Consumer Law Center, of course, has some wonderful resources, as well as the National Association for Consumer Advocates, if you have questions.
Let me just say one thing about our resources, which is that they include both summaries of the laws that apply and also advocacy materials. But as the CARES Act evolves over time, potentially, there'll be more information on the COVID page, and there's a housing section.
Yeah, and we really appreciate that. I know you had a large hand in that, Alys, and we always appreciate everything the National Consumer Law Center does to help keep us on track. Okay, so this, I think we've talked about it quite a bit, of the different types of loans and what the acronym definitions are. And so the first thing obviously is you need to try to figure out if your loan is a Fannie, Freddie, FHA, VA. Generally speaking, if it's a VA, it'll be pretty obvious from the face of the documents. Same is true with FHA. If it's Fannie or Freddie, you can look up by borrower and address. But if it, I mean, quite often you're going to see Fannie or listed on the bottom relating to what the type of document it is. Doesn't mean it is a Fannie loan, doesn't mean it was a Fannie loan. It means it may be a Fannie loan. So, and even if it was at the beginning, either Freddie or Fannie, you still need to check to make sure. The other two statutory references are references that provide you the option of contacting the servicer to find out who the owner is and what type of loan it is. And so that's a way you can get information without being at the mercy of either the servicer's representative getting back in touch with you or the attorney for the plaintiff if it's in litigation getting back in touch with you. And bear in mind, I'm not sure of everyone's experience, but it has been taking servicers quite a bit of time to answer the phone or return messages. So this is basically additional information about what I just spoke about. I did want to mention though that a lot of the FHA loans that were delinquent were sold through the Distressed Asset Stabilization Program. So even though you may have that box on your mortgage documents, your client's mortgage documents that say FHA number, et cetera, it doesn't mean it's still an FHA loan. So you might need to check on that as well. I've been getting information from my cases that are in litigation. The plaintiff's attorneys are contacting me and canceling hearings because they say that the case is on hold. I'm not quite sure what that means. I will find out, but these are loans that are where it surprises me are the traditional loans, because I was afraid I was going to have trouble getting them to recognize the CARES Act provisions for FHA and VA, but they're going over, some of them are going overboard on conventional, so that's helpful. So here is another reference to how you can contact the different agencies involved. And also the CFPB has a coronavirus mortgage relief opportunity. I was on the phone with some folks from the CFPB yesterday, their Older Americans division, and they were begging us to please file complaints with them because they don't notice there's a problem with something unless there's a large volume of complaints. I'll leave it at that since this is being recorded. But anyway, if it's an older person, you can even contact the Office of Older Americans with the CFPB if you're having trouble with your servicer. So I have mentioned notices of error and requests for information. This is something we're going to get into in great detail, but just for reference, these are two opportunities that became available on January 10th of 2014 when that part of the Reg X regulations became effective. And these are tools that you can use to notify your lender of what you believe is an error or request for information. And we will talk more about that in a few minutes. Okay, and I think Alys is going to talk a little bit more about how to get the forbearance.
Yeah, we're going to get into some further detail, but I just want to flag a couple of things based on some questions in the chat. One is everyone's going to get a copy of the slides. So don't worry about writing down citations and details, and also all those blue links that you see in the slides. They're links in real life in the slides, and so they'll be there when you get the slideshow, and you'll get the extra information there. Just we wanted to hook you up with the relevant letters and guidance that the different agencies put out, and so those are embedded in those slides. So I don't know how this happened, but in all the editing and unediting of the PowerPoint, we didn't put in a slide about the foreclosure moratorium under the CARES Act. So I just want to mention it for a second. So when it passed in March, there was a foreclosure moratorium for all loans affected by the CARES Act, meaning all of these federally backed loans, which means if your client has a loan that's not federally backed, there is no official foreclosure moratorium unless there's one in the state, and that's almost no states. And even in the states that have them, there's sort of these pretty please try not to foreclose moratoria. They're not real in most cases. So, and in Florida, as you saw, it was just about evictions. So it was only for a couple of months. The agencies all extended to the end of this year. So that's really helpful. It's likely that they'll extend a little further unless there's a miraculous recovery for the country sooner. But that doesn't mean that people don't owe money and aren't in danger of immediately being in foreclosure when the moratorium's over. It just means that right now, there's not supposed to be one. And we have heard of cases where there are foreclosures, but know that that's a violation of the moratorium. The other thing I want to say is the CARES Act is not part of any consumer statute. It doesn't have any obvious way to directly enforce the provisions in it. There might be some creative ways that we describe in a later slide about how to try to do that. But for the most part, companies are supposed to be following the rules. And if they're not, and it's a federally backed loan, there are government agencies who theoretically care about that, and Lynn and I can help you with that. So the big tool that's available in a forbearance, and really I want to emphasize that I think COVID is different from natural disasters in this way, is that forbearances are the most common form of help that people are getting. And in a natural disaster, the damage is such that people are normally looking for a longer term solution, even upfront. And there's usually a moratorium to give them that sort of cushion before they get that longer term solution. So in the CARES Act, you get a forbearance, which is essentially permission not to pay your mortgage temporarily. And this is what the statute provides. It can be asked for either orally or in writing. It doesn't have to be in writing. And the borrower basically has to state that they're having a financial hardship due to COVID-19. That's all it says. It could be that the person was sick, the person's unemployed, they have increased expenses because they're, working at home, or they have to work less because they have to take care of their kid who's doing Zoom school in the next room. Any of those are COVID emergencies, and my understanding is that services are being relatively flexible about that definition. And here's the key thing related to the survey from before: no supporting documentation needed. All you have to do is say you're having the hardship. Otherwise, it's a violation of the CARES Act. So as I just said before, the forbearance doesn't mean you don't owe the money later. It means right now you're either making no payments or you're making reduced payments. But later that amount is going to need to be repaid. And also, if someone doesn't have an escrow account where they're paying their taxes and insurance to the mortgage company, which then makes their payments for them, then they still owe those amounts. And they're going to need to be paying attention to that even if they have a forbearance. And the other thing I want to point out is you can get a forbearance, and then if some months you're able to pay, you are allowed to do that and you're still in forbearance. So very briefly, it's in section 4022 for people who want to go find it. And the key thing here is it's unclear how long you can get a CARES Act forbearance for, because there is no covered period in the section, because it's sausage making. And I will tell you that I personally was on the phone with Senate staff at 5 o'clock in the morning, negotiating and fending off terrible provisions that we were able to get out, even though we didn't get everything we wanted in. And so a lot of people are relying on the next section, which basically says till the end of the year or earlier if the national emergency ends earlier. I want to point out that FHA put out some guidance saying that you can only get a forbearance till the end of October. And they're in the process of fixing that because they messed up. And our understanding is that they're going to extend that. We hope till the end of the year at least. And we hope longer than that. And when we spoke to Fannie Mae and Freddie Mac, they said our availability of forbearance is related to COVID. It's not related to the deadline statutorily. Meaning, if in February someone is affected by COVID, but the CARES Act hasn't been extended, and you have a Fannie Mae or a Freddie Mac loan, you can still get a forbearance under their rules. And you're not stuck with the regular rules. Okay, so one question is, can you make your payments? Do you need a forbearance? And then the next question is, how do you pay that money back? And so most of the rules now are relatively similar. And so there are a lot of details in here, but the big picture is this, and this is a slide about what Fannie Mae and Freddie Mac do, the GSEs. They have this thing called the payment deferral, which is based on something similar that FHA has called the partial claim. And so what it basically is you take the amount that you didn't pay before and you put it at the end of the loan. It was like a non-interest bearing loan for the time you didn't pay. You put it at the end, there are no extra fees. And it's a balloon, meaning you owe it all at the end of your loan, and you either can refinance or you're selling your house or you take out a new loan, just sort of depends on your circumstances. That is at the top of the so-called waterfall in terms of what your options are, the deferral. The first bullet is just about how the CFPB put out something making it possible to provide these things to people without going through a whole application. So the first option is a deferral, and someone could get that during a forbearance. They should ask for it. If they don't, Fannie Mae and Freddie Mac are going to send an offer of one to the person anyway, and they're going to have a couple of weeks to accept it. FHA and other types of companies probably are not going to just mail you an offer. They're going to want to talk to you. If you can't afford to resume your payments and you weren't also relatively on time with your loan, then you're going to need a modification instead of a deferral. So FHA's put out some guidance. This is a slide just showing you what the guidance is, and then the next slide, which we can go to now, has a little bit more information. This is the so-called COVID Waterfall for FHA loans, and this is the mortgagee letter, which you can just Google that and you'll get all the details. But essentially, the partial claim is like the deferral. If you can resume your payments and you weren't 30 days or more late, then you can just put the amount you didn't pay at the end of your loan and start resuming your payments. If you need some sort of lowering of your payment and you weren't late, there are these special options available. The last bullet is showing you that if the person was more than 30 days late, and a lot of people were already late before COVID, they're just more late now, then they're going to just go back into a regular loss mitigation regime where they're going to get, for FHA purposes, FHA HAMP, or for any other kind of loan, they're going to need to lower their monthly payment. So this is a slide explaining what the FHA partial claim looks like, and that's similar to the deferral. And the main point here is it's at the top of the waterfall like it is for the GSEs, and it's a non-interest bearing lien. So that's what we were just describing. So it's just a reminder about that. This next slide is very important. I'll just say a moment about it, and then the DeLong case is described here again. So I think somebody asked me about the citation. The key here is the CARES Act itself is not privately enforceable, but when companies do the wrong thing, there are a lot of other arguments you can make. You can make an argument that the regulatory requirement is there and should be complied with. You can try to enforce the regulations directly. You can say it's a condition precedent to foreclosure, meaning they have to do that before they're allowed to start a foreclosure. You can use the loan contract, especially if it's an FHA loan, to incorporate the notion that, the contract says the company has to follow FHA's rules, and since they're not doing that, they can't enforce the contract. And then I'm going to turn this over to Lynn to talk about this again if she wants to, and if not, I'll just go on and talk about reverse mortgages briefly. Is there anything else you want to say about that, Lynn?
Oh, thank you, Alys. Just very briefly, Laws v. Wells Fargo is the FHA analogy or analog case to DeLong, which references the VA pre-foreclosure servicing requirements. There are a lot of cases like Laws that you can probably find by shepherdizing it, but there are several cases relating to denial of or rejection or a defense victory if it is an FHA or VA loan. I'll just stop there.
Okay, we're going to talk about reverse mortgages for a few minutes now, and there'll also be some information in the disaster section about it. As some of you may know, the thing about a reverse mortgage is it's a reverse mortgage. And so the person receives money from the company rather than makes payments. They might get it in a lump sum, They may get it monthly. And it allows a lot of older people to age in place, essentially. At the same time, the homeowner still needs to be paying their taxes and insurance. And if they don't, that's essentially a condition precedent to getting to keep the mortgage. And so when people hit financial trouble or they have health problems, often they're unable to keep paying their taxes and insurance, and they may have challenges related to that. And these rules address that question. The other issue that these rules address is if two people are married and one person is substantially older than the other, it may be that the older person got the reverse mortgage and the other person who's younger doesn't get the reverse mortgage. They're not on the loan. But if the older person dies and that's the loan, then the younger person's not on the loan and may have a hard time getting the mortgage company to pay attention to them, to accept their payments, and especially to lower the payment if they need a lower payment. We're going to go back to that other slide again, and I'm going to now go through the details on slide 45. Okay, so these are specific COVID rules just for reverse mortgages, and the key here is it's similar to what the CARES Act provides, and we didn't really go into this detail before, so I'll explain it now, which is you can get a forbearance for up to 6 months, and then you can ask for an extension of that forbearance for up to another 6 months. That's how long the CARES Act forbearance is in general. So that also applies if you have a reverse mortgage, except here the payment isn't the mortgage loan payment, it's the payment of the taxes and insurance. And if you're not able to make that, then your mortgage is in trouble. And so here it's giving you an extension for the amount of time to kind of get your house in order, which is important. And the other thing that it's extending is if the borrower on the reverse mortgage dies and the non-borrowing spouse is still in the home, they have certain deadlines that they need to meet, and those deadlines are also extended by the same deadline in timeline of up to a year. The other thing is that there may be people who have reverse mortgages who fell behind on their taxes and insurance, and they're already in an active repayment plan for those property charge defaults, and they can get a forbearance on that payment plan under the CARES Act. So HUD has been very flexible there, and that's been very helpful. Now we'll do the next slide. So there's two categories of people who are the non-borrowing spouse or the survivor. If my spouse died and he was on the reverse mortgage or she was on the reverse mortgage and I wasn't, then I have to figure out what to do as the survivor to get acknowledged and to essentially get to stay in my house and to keep the mortgage going. And so for people who got their loans more recently, after August 2014 or kind of the middle of the month, there's a new rule and people essentially have 90 days after the person dies to raise their hand. But that timeline is being extended by the CARES Act for another year. And so that's very helpful. That entire extension is applying in that circumstance. And then in the next slide, you'll see the rule for most people who have reverse mortgages got them before 2014. And there's a very specific process they need to go through, the surviving spouse, to raise their hand and be able to stay in their home. And that entire process has also been extended for up to a year. So the actual deadline for raising their hand was last March, right when the pandemic was starting. And instead, what we've got is an extra year because of the CARES Act. So that's been very, very helpful. So just a quick reminder that borrowers who can't pay their mortgage can really benefit from a Chapter 13 bankruptcy. The thing about a Chapter 13 is you can make arrangements for paying your mortgage in a Chapter 13. This is a specific slide about how it could help for a reverse mortgage borrower. And there are some details in here. I was going to turn it over to Lynn so she can just walk you through a couple of these, and then she'll take it from here to start the disaster section.
Thank you, Alys. And I did want to mention there are still some questions that remain relating to reverse mortgages and the differing extensions and timelines. And Alys and a couple of her colleagues worked on a very thorough letter to HUD just to try to get some clarification on some of the gaps in discrepancies between the mortgagee letters themselves and prior custom with reverse mortgages. So that's available if anyone wants to contact me directly. But I did want to mention that the two cases at the bottom, particularly Mashad, Harmon was a case that was handled by our office, and Mashad was a similar one where a survivor was filing a bankruptcy case to try to pay the amounts that were due under the reverse mortgage for survivors. And the bankruptcy court allowed the heirs to proceed with a repayment, Chapter 13 repayment plan as survivors because of the death of the borrower or main person was not considered it is a default in a reverse mortgage. Death is a default, but it was not the type of default that would harm the person who was trying to get relief through a Chapter 13 bankruptcy and pay off the loan. So next we're going to talk about disaster options. I'm going to talk about just a few very minor things and go through these really quickly and then turn it back over to Alys for the forbearance. But so you figured out what type of loan, you've checked on the foreclosure moratorium, specifically nationally, you have eviction may or may not be relevant. So what I'm going to talk about are credit reporting and late charges, and then Alys will cover the forbearance and loss mitigation. So credit reporting, we don't have a lot of guidance for all types of loans, but for you can see what Freddie and Fannie have said about suspension of credit reporting. For Freddie, no reporting if in for negative reporting if they're in a forbearance or repayment or temporary payment plan. And it's very similar to Freddie, but not as broad as Fannie's temporarily suspending credit reporting for delinquencies. But there's some differences in older versions of their guidelines, so it's somewhat up in the air. Given the state of FCRA litigation now, I'm not sure how much I'd want to push whether or not what they're doing is right or wrong, but you have that information. So FHA, they have the servicer must suspend reporting of delinquency if it's disaster related and the borrower is doing what they're supposed to be doing, which is basically nothing if they're in forbearance. VA encourages suspension of credit reporting, and the USDA no delinquency reporting.
But can I just say one thing, which is we didn't put in a credit reporting slide for COVID.
Right.
The COVID policy is different, which is whatever you were before, you still are. So if you were on time when you needed a forbearance because you saw that you wouldn't make your next payment, you'll still be reported as on time. If you were late, you're still supposed to be reported as late. Thank you.
Thank you. And so late charge suspension, you see Freddie, Fannie, somewhat similar to their stances on credit reporting. I'm not going to go through those, and you can see the FHA, VA, and USDA rules or guidelines relating to credit reporting. And so I'll turn it over to you, Alys, on the forbearance.
So before we talk about forbearance, I just want to say a couple of things because this is my last group of slides and then Lynn's going to finish up. One is I didn't say this at the beginning because we were kind of in the middle, but I just want to thank you for having me. There are a lot of really great people in Florida doing incredible work, and it's a real honor to be a part of that. Thank you to Kathy for organizing. Thank you to Carlin for keeping track of everything. And let me just say that it's a real honor to work with Lynn. When I first started at the National Consumer Law Center, Lynn was already a luminary. She was already walking around at our conferences knowing a ton, and it's really a great opportunity to be here with everybody. That's all I wanted to say, other than everything we're saying today could evolve, and please stay tuned. So this is about a forbearance that you might be able to get in a disaster, and we're just walking you through what the policies are for the GSEs on this slide, and then in the next policy, in the next slide, it's for the next one over, and they're 12-month forbearances, and that's very similar to what you can get under COVID, except the rules are slightly different in terms of what you might have to show, or whether you have to get it renewed after 6 months. I want to point out that on this slide that, while Fannie and Freddie essentially require the offering of a forbearance if you need it and you can meet their standard, and that's also true for FHA, the VA and USDA only encourage forbearances, and we haven't been able to fix that. So other than the forbearance, the real question, especially after a natural disaster, is can you afford to resume your mortgage payment, or are you going to need to make a change? And so this is, I think, the clearest waterfall of all the ones in all the slides that we have. This is for Fannie Mae and Freddie Mac. It starts with this payment deferral. That's the plan that if you can resume your payments, you resume your mortgage payments, and the amount that you owed goes on the back as a balloon. There used to be these other modifications for people who have done this before, the disaster mod and the extend mod, which were, essentially what was similar about them is that your loan term got longer, and the big difference is now that in the deferral, your loan term's not getting any longer. You're just going to owe the total at the end of your loan term. And as of now, the deferral is the required top of the waterfall. And then if you can't resume your payment, you're essentially looking to get a loan modification. We're very interested in learning whether this flex modification from the GSEs, which is anything but flexible, it's a one-size-fits-all payment decrease based on a percentage of your payment. We're very interested in knowing whether those are affordable for your clients. Ever since before they were announced, we've been very concerned about that. So if you have any intel about that, I'd really appreciate you sharing it. And then obviously, if you can't afford a modification, there are different ways to lose your house more or less gracefully. So FHA has an automatic foreclosure moratorium of 90 days that happens after a natural disaster. And that's very helpful. And you can see here in the later slide, in the later bullet, information about these non-borrowing spouses that we were talking about before. So their deadlines get extended. The last bullet is interesting. If you've got a presidentially declared, major disaster area, then the deadline for the company to file the foreclosure is extended for 90 days, so that the person has, an opportunity to apply. So this is after the moratorium. You've got the 90-day moratorium, and then the company has to file foreclosure 90 days after that if payments aren't being made. The tricky part is they can file foreclosure earlier. They don't have to wait that 90 days, but they may. And so your client theoretically should try to get a loan modification before that 90 days is over, but the foreclosure may start anyway. And we're trying to get them to fix that. They have a very similar policy for COVID, and we're concerned about it. Let us know if you see problems with that. So there are two kinds of FHA mortgages, the regular kind, forward mortgages, and the reverse kind. So this is a slide about the forward mortgages. You can get a special kind of modification, not just the regular FHA HAMP, where essentially you can extend, the loan up, to a 30-year loan, and you can get one each time there's a disaster, which in Florida might mean that some people have certainly had more than one. And then there's, again, this partial claim, and it can be combined with the loan modification. So you could use some of the tools of the modification to lower the payment and then also stick some at the end. And that is often what makes the payment affordable for people. Just one term to share with people, this idea of the trial payment plan. The trial payment plan is, 3 months at the beginning where the person has to show essentially that they can afford to make the payment. I know we're at time, and I think we're going to go over for just a few minutes, and so we want to get this information to you guys, and we appreciate it. So a big issue about reverse mortgages is the whole idea is that you're aging in place. And so you're supposed to live in the home. But after a disaster, and sometimes just because you're sick and you're in the hospital, but certainly after a disaster, people are displaced. And so these slides are about ways in which people have faced challenges showing that they're still in the home and that it is their primary residence, even if they're living in a trailer because their home is uninhabitable. And so essentially the forward rule, which doesn't technically apply to HECMs, but to reverse mortgages, which are also called HECMs, is that as long as you can show that you're intending to return to the home, then you get to stay on the mortgage. And so that's an argument you can make similarly here, even though the rule isn't as clear. And also the second bullet is talking about how you can also designate other people, because especially reverse mortgage borrowers may have a hard time keeping up with everything. So Lynn knows a lot more about HECM occupancy issues, but let me just say that people have a variety of options if they're facing default because they're perceived as having moved out. They can move back in. They can show documentation that it's still their primary residence, like utilities or other bills like that. And they can describe that it was a displacement just due to a natural disaster. And if they're having other challenges with certification requirements and they're over 80, there are also additional accommodations that they can get through the at-risk extension. There was a woman in Puerto Rico who was displaced after Hurricane Maria, and she got a notary essentially to help her put a letter together with her legal services lawyer proving that she lived in the home. And she signed it with her thumb because she didn't write. It was a big deal, but she worked with her lawyer and she sent it in and she got to stay in her home. So there are ways to do that, but it requires, some hoops to go through. Just briefly on the last slide here, and I'll turn it back over to Lynn. These are disaster rules for VA and USDA. There are some options. For VA, there's no more trial period plan. The big thing I would say about USDA loans is figure out if it's a direct loan or a guaranteed loan. The rules are very different. The rules here are for guaranteed loans. The direct loan options are much more limited. Thank you for having me.
Thank you so much, Alys, for doing this. I can't just say how much I really appreciate it. And I know that we are past time, but I understand from Kathy that we have a few more minutes. So I wanted to thank you, Kathy, and Carlin. As always, y'all have really made this an easy process for us. And so if y'all will just give me wait, where am I? The 5, 4, 3, 2, 1, when you want me to get ready to stop, and I'll shut it down, but I'll keep going until you tell me. And if I don't get through everything, again, you're welcome to contact me individual, and I will answer any questions you have.
Okay, great. And I was going to say, if you have to leave early, don't worry, we're recording all of it. So you will get that as well as all the material.
Okay, so now we're going to talk. Now this is a poll question that I'd like for folks to answer, and we'll do this one very quickly. Basically, we'll go ahead and launch that while I babble on, Carlin. Basically, we're just going to find out a general idea of the people who are attending's familiarity with Reg X and the notice of error and request for information options. And again, this is reverse mortgages, which Alys did perfect on, and Reg X are kind of my two things I really like to do. So please feel free to contact me about either, but Alys gave you all the information you need. Okay, so it doesn't look like there has been a robust notice of error and request for information use within the audience, and that's fine. I think if is something that you're interested in, you'll find them very useful tools. So, and we'll keep going. So the CFPB servicing rules found in Reg X, specifically 12 CFR 1024-41 with respect to loss mitigation, applies only to mortgage servicers. So you have to make sure if you're going to send and I'm going to talk specifically about notices of errors and requests for information just to keep it simple. If you are sending a notice of error to the entity that owns your loan, for instance, if you have a Fannie Mae held own loan and you send a letter to Fannie Mae telling them that their servicer is not handling the mortgage correctly, they'll probably ignore it without consequence, perhaps. But if your true intent is to get information or to make the servicer aware of an error, you want to make sure that you send it to the right person, you send it to the right address. If it is not sent to the designated servicer's designated notice of error request for information address, it can be ignored without consequence. And that's a bit of an overstatement, but we'll just go with that. You just want to make sure you send it to the right place. If the servicer does not have a notice of error or request for information address on the monthly statement sent to the borrower or on their website, you can send it to wherever you think will be most effective, but you really need to make sure that you're getting it, you have the right address. So it's gonna cover the most first lien loans, Fannie, Freddie, FHA, VA, etc., but not for open-ended lines of credit or reverse mortgages. Now, I will say that specifically relating to the notices of error and the request for information, not the site I just provided for loss mitigation, you can send a notice of error, and I've used them rather robustly in my reverse mortgage practice, and you can also send a request for information, because although a reverse mortgage is not included in the loss mitigation portion because you don't make payments, the Reg X notice of error and request for information do apply to reverse mortgages. But these are the differing areas that the CFPB servicing rules, Reg X, apply to. There's a real nice 2-pager printout that the CFP put out back in 2014. That's the simplest and most thorough explanation I have seen about what what is covered under the CFPB servicing rules and Reg X and what is not. So the next slide, and the next slide. So what is a request for information? Exactly what it sounds like. And what's a notice of error? Exactly what it sounds like. If you're trying to figure out who owns the loan, to figure out what type of loan what type of relief options you have, a request for information may satisfy that, or a request under the Federal Truth in Lending Act. Notices of error, I mean, you can read the slide, but obviously I'd like to make a couple of comments about notices of error. One, and again, I can't emphasize this enough, send it to the right address. Actually have an error if you're going to send out one of these, and tell the servicer what you believe the error is, and then tell them, exactly the things that you need, information or documentation to help explain the error, and ask them to look into it, and they can write you back and say, we don't think there's an error, deal with it, or they can fix the error. So if you find yourself, and you will in many instances, having to send a second notice of error, make that equally as targeted and specific. I know it has been a practice at the beginning just to throw everything in the plus the kitchen sink and a notice of error or request for information. Please don't do that if you want it to be taken seriously. Ask for 5 bits of information, tell them 5 errors. And if you send a second one of either, make it just a little bit different than the first one you did. Think dispute letters and FCRA litigation. So these are the types of things, and then we'll move on from that slide without me going into it any further, of the different things that you can claim that there has been an error relating to. I just worked on an amicus brief that was filed in a case where the court, circuit court, I believe it's second, I could be wrong on that, but anyway, the court found that loss mitigation and default servicing was not servicing pursuant to the CFPB regulations, and so you couldn't send a notice of error relating to a loss mitigation servicing issues. I'm assuming the same with the RFI. Some very talented people who are members of NACA, and with the help of NCLC. And also NCLC was on the amicus brief that we wrote in that case. And so hopefully the court will do the right thing in that instance. So not covered, the beginning of the loan, the underwriting of the loan, duplicative overbroad, 1 year after the loan has been satisfied. So these are sorts of things I was already talking about, but remember, origination and underwriting by definition don't really relate to the collection or servicing of the loan, so that is somewhat intuitive. And so the good thing about, and I've just got about 2 more minutes, the good thing about notices of error and requests for information, this provides the servicer, they have deadlines, they have timelines. I usually send mine certified mail, return receipt requested, because they have 5 days to acknowledge receipt and 30 to 45 days, depending on what you're requesting, to respond. If it's a dual tracking issue, and keeping in mind dual tracking is when the servicing arm of the loan, they're going forward with loss mitigation and maybe even putting you in a trial payment period, but the litigation side is going full steam ahead as if nothing was going on the loss mitigation side. And I wish I had the time to tell you several stories that would just shock you about individuals in different departments with servicers do not communicate, and they communicate even less with their attorneys. So if you assume that the attorneys know what the servicer's doing, they don't. The attorney knows what the owner's doing, they don't. That the accounting department knows what the servicing or the collection department knows, they don't. They don't communicate with one another at all, which you can use to your advantage, but it can also be very frustrating if you're not using these tools. Okay, I've talked about that quite a bit, so I won't mention anything further about that, and we can move on to the next slide. So in a response to the notice of error, the response has to be either the error has been corrected, or after reasonable investigation, we don't think there's an error, and this is why, and that last part is very important. Jeff GOV'T was a big part of the underlying case, Renfro, which you can find is a very good case on notices of error with servicer violations. So I believe we are nearing the end. This is a book that you must have, if I can say that. It is really the guidebook that I mean, I think every legal services program in the state has a set of these that are dog-eared. And maybe not so much now that everything is electronic, but for old folks like me, they still like to use books. Mine's pretty worn. And so that basically is the end of the presentation for today. So I'll stop talking. There are several more slides, and you're welcome to contact me if you would like. And I may bug Alys some if she doesn't mind, but we really appreciate your patience with us and going over the time. We appreciate your patience with us going so quickly. And we just appreciate what you're doing, and just keep doing it.
All right. Thank you, Lynn and Alys, for the presentation today. And thank you all for attending. And as I said earlier, you'll get all this information. Probably next week, we'll get the video, the PowerPoint, and all of the information, along with an email address from Lynn and Alys. And I hope to see you back next Thursday, because next Thursday we'll be talking about renters. So thank you all, and thank you, Carlin, for helping today. Bye, everybody. Bye-bye.
Thanks.
Bye.